Hello everyone, I'm Jeff Hampton with the Fulgham Law Firm. Welcome to our video series here on our YouTube channel. Today I'm going to talk to you about 5 ways to beat a DWI case. And by the way, if you wait around till the end of our video, I'll also give you a free ebook, The Ultimate Guide to DWI Defense in Texas. All right, let's break this down. Now, one of the things I want to start off with doing is let me just give you a quick guide, a glancing view of DWIs in Texas. First of all, not that it necessarily matters, but you know, of the states we have in the United States, we are nearly in the top 10. We're literally like on number 12 or 13 in the country when it comes to the strictest DWI laws in the country. So what does that mean? Well, that means that if you're facing a DWI charge, you're facing some potential tough penalties, both potential jail, probation, as well as very serious fines, court fees that could be assessed as a result of your DWI. So if I were sitting where you were sitting right now, or a loved one of yours is sitting, I'd want to know, okay, what am I looking at if it's my first DWI? And then we'll march it forward from there. Number one, penalties for a first DWI offense, they're pretty steep. One of the things to be aware of is you could face a fine of up to $2,000, and that just includes a fine. You could also spend anywhere between a minimum of 3, up to 180 days in jail as a potential jail sentence. You could have a suspension of your driver's license for up to a year, and you could end up having, they used to call them surcharge fees, but actually now I kind of call them a DWI tax, where if you're convicted, DPS, the Texas Department of Public Safety, can actually make you pay a fee, a fine, of anywhere between $1,000 to $2,000 a year, every year for the next 3 years if you're convicted of a DWI. If you move up to a second DWI, your fines can get up to $4,000. You could spend up to up to a year in county jail, and you could end up with a driver's license suspension of up to 2 years, where you'd have to get an occupational driver's license. And of course, you know, every bit of this involves quite a significant amount of money. And then you could end up having an additional surcharge up to that $1,500 to $2,000. And I keep calling it a surcharge, but it's mainly a fine. It's a fee. It's the privilege for you to be able to still operate your license and operate a car. You have to pay a tax for that. So those are some of the ramifications of a misdemeanor DWI. Now, if you happen to be charged, what if you're just driving and you have a DWI, but there's a child in your car? If there's a child in your car, you are now elevating your consequences potentially to a felony now. You're now talking about, and they don't even care, quite frankly, the state of Texas doesn't care if it's your first offense. It's automatically charged as a felony, and it's what's called a state jail felony. So a state jail felony is punishable by a minimum of 6 months up to 2 years in a state jail facility and up to a $10,000 fine. You could also have a driver's license suspension as a result of that as well. And by the way, look, I'm not trying to say this has happened. I just want you to understand you could face some additional consequences. We have seen instances where people, if they have very high blood alcohol levels and they have a history of issues with alcohol, they could temporarily lose custody of a child, and that could also create some pretty serious issues with child protective services as well. All right, now let's talk about some of the defenses that we're going to look at here. Now, one of the things that we look at, Texas is a state in which a motorist can get a DWI actually without driving. Now, it sounds counterintuitive, okay? So when we think of driving while intoxicated. You need to be literally driving down the road. But the actual definition of driving under the law is an individual, let me just give you the breakdown of it. An individual must be operating a motor vehicle in a public place while intoxicated. So my point on that is you don't have to actually be moving the wheels on your vehicle down the road in order to get a DWI. Amazingly, we have seen police officers choose to arrest people. Think about this for a second. We had a client who went to a bar, realized they shouldn't be driving, right? Shouldn't be driving. They're going to sleep it off. They get in their car, they turn on the car because it's 100 degrees during the summer at night, even at night, and they want to cool off and just sleep it off. Well, they turn on the car and they're asleep in the car. The police officer, they walk up knocking on the door, and what do? Step out of the car, sir. They arrest them for DWI because their car was on. Okay, they're making the claim at that point that they are operating that motor vehicle. So many people don't realize this, that could be an issue that arises. And we'll talk about that as one defense here in just a minute. Now, one of the biggest things we look at is, was the stop, let's say a police officer pulls you over to stop. Number one, there may have been an improper stop. Okay, in order for a police officer to pull you over for a DWI, they must have reasonable suspicion that you're committing some type of crime. The police officer cannot have just a mere hunch or a gut feeling that you're committing a crime. When you're pulled over, the police officer must be able to articulate in their report and on their dash cam or body camera, they must be able to articulate a specific legitimate reason for why they are doing so. And usually you can find that out if they're just doing it on a hunch or not by what they're telling the person when they pull them over, or what they're able to observe when we look at that dash cam video. So an improper stop, an illegal traffic stop, is one of the most common arguments or situations that we look at in a case, because under the law, if a police officer pulls you over illegally, everything after that traffic stop is illegal. It's inadmissible. Okay, so even if your blood alcohol level was 4 times the legal limit, it's inadmissible in a court if the traffic stop itself was not legal. Now you say, well, what makes it legal? Well, they're looking for a traffic violation. All right, were you speeding? If you were speeding, did you fail to use a blinker? Were you weaving in and out of your lanes? Were you driving recklessly? Did you fail to stop at a stop sign or run a stop? I mean, all of those are examples of traffic violations that allow the officer to pull you over and look in more detail into your situation. But if you didn't actually commit a traffic violation, you could end up having a very strong defense that there was an improper stop. Okay, so that's number one. Number two, what about if the officer is relying upon information that is mistaken? And what I mean by that is, you'll find situations, legitimate circumstances and conditions where an officer might think someone is drunk, but they're not. And what I mean by that, let me give you an example. Let's say that maybe you've been working like 2 12-hour shifts, or maybe you've only had 4 hours sleep over the last 2 days. And we find that happens all the time with nurses and emergency medical personnel that's going on. They get pulled over for a DWI because they've been working these shifts trying to help people at the hospital. And the officer looks at them, and what do they have? Bloodshot, watery eyes, right? And sometimes they have slurred speech. They're not thinking real clearly, because some of the same effects of being exhausted they kind of seem similar to what you might find if someone's drinking alcohol. And so remember, you can also be arrested not just for alcohol, it can also be for medication, for drugs, whether it's prescription medication or illegal drugs. And so sometimes the officers just jump to conclusions. They just assume that if you appear this way, it has to be because you're intoxicated from some type of substance. And so another thing that we find is we've had some people that have been sick. Maybe they have sinus troubles. We had another guy who had pink eye. The officer just gets them out and starts having them do field sobriety tests, and they're scared to death, and they fail those tests, and now they're arrested for a DWI. So one of the things we look at is an officer relying upon mistaken information. Okay. Now, what's the number 3 reason? What about lack of probable cause to arrest you? Now, understand this. When a police officer pulls you over, gets you out of the car, he has to now develop probable cause to arrest you. And one of the ways they do that is to administer field sobriety tests. Okay. Now, I could spend a whole nother video series on just field sobriety tests, but I want you to understand there's 3 main ones: horizontal gaze nystagmus, walk and turn test, and the one-leg stand test. If that police officer does not administer those tests properly, okay, if they're not done correctly, then under the rules promulgated by the National Highway Traffic and Safety Administration, they're not reliable. So one of the things your attorney absolutely needs to do is to break down how they were administered, if they were administered fairly, or there may be some other reasons to explain why you might not have done well on those tests. What if you had knee surgery? What if you've had some serious problems, medical problems that would prevent you from doing physical tests? And I'm just going to tell you another one. The handbook that the officers are trained on says that if you're overweight, if you're considered obese or overweight, it's not a reliable test. All of these things need to be taken into consideration. Did the officer actually have probable cause to arrest you? Finally, what about just not intoxicated at the time of driving? There is a concept known as extrapolation. This is number 4 out of our 5 here. But An officer, when you take a blood test, what does that show? That shows what your blood alcohol level is when you took the test, not necessarily what your blood alcohol level was at the time you were driving. So the officer is going, or the district attorney's office is actually going to have to go back in time to try to extrapolate to see what your blood alcohol level was at the time you were driving. Well, that can become a problem if your blood wasn't taken for 4 or 5 hours. What if you took a blood test and your blood test was taken 4 hours after your stop, but that blood test came back as 0.09? Well, I want you to understand, we absorb alcohol at 0.02 an hour. The normal person does. So you have to take that 0.02 and multiply that by 4. You could be as high as 0.08 higher or as low as 0.08 lower. So you can do the math on that. That now creates a big range of what your blood alcohol level could have been. That can create reasonable doubt. Please understand, you have no burden to prove your DWI at all. The state of Texas must prove that you are intoxicated and that you were operating a motor vehicle, and they must prove that beyond a reasonable doubt. So not being able to show what your blood alcohol level was at the time you were driving can be a very valid defense to your DWI. Finally, this is a very rare one, but a necessity defense. We represented someone one time where there was a young woman who was dying from a drug overdose. I mean, she was clearly dying from a drug overdose. She was literally foaming at the mouth, and it was really a serious situation. Our client had been drinking. He was at a party. He just jumped into survival mode. He got her in the car. He raced as fast as he could to get her to the hospital. In fact, he did get her to the hospital, saved her life, in fact, and got her there. And in the process, guess what happens? The police show up. In fact, they're following him all the way to the hospital. They arrest him for DWI. Well, under the necessity defense, if you're doing something in order to prevent a greater harm than the harm caused by driving while intoxicated, that is an actual affirmative defense that can be used in your case. All right. So there you go. There's 5 valid defenses that might apply, something for you to consider in your situation. And you know, there's many other things I could get into. We could get into your body composition, the amount you actually had to drink, the time that had passed, medications. I'll do a whole nother video series about drug DWIs and how that applies to this in ways that they try to calculate intoxication that way. But I promised you that if you waited around to the end of this video, I'd give you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. If you click the link right here below, I'll be happy to send that over to you. And if you liked what you heard today, like our videos, subscribe to our YouTube channel. And if you have a case out of the North Texas area and you would like a free consultation and like to speak to us, don't hesitate to contact our law firm at 817-877-3030. Thanks again for joining us today at the Fulgham Law Firm on our YouTube channel. Look forward to seeing you on our next video series.